Welcome, and we will call the Senate Judiciary Committee to order. Committee, we first need to approve minutes. The minutes should be in your committee folder. I'm sorry, they were sent to you online. The minutes for February 4, 5, 8, 9, 10, 11, 16, 17, 18, and 19. Committee, yes, Senator Baumgardner.
Madam Chair, I move we approve the minutes.
Do I have a second? Senator Wilborn. Committee, you've heard the motion. All those in favor, aye.
Aye.
All those opposed, no. The motion carries. Thank you, committee. Committee, we will next open the hearing on Senate Bill 304, removing the sunset provision in the COVID-19 Contact Tracing Privacy Act. If we could have a brief summary of the bill from the reviser, Mr. Thompson.
Thank you, Madam Chair. Good morning, committee. This is Jason Thompson with the Reviser of Statutes Office. Senate Bill 304 removes the sunset provision in the COVID-19 Contact Tracing Privacy Act. That's KSA 48-961 that you enacted last year. It removes subsection L that provides the section shall expire on May 1st of 2021. I note that the definitions in subsection K continue to limit applicability of this section to contact tracing related to COVID-19. So it's just that contact tracing, not any other contact tracing that might be applicable to any other disease. And I'll stand for questions.
Thank you, Mr. Thompson. Committee, questions for the reviser? Seeing none, then we will let's see, we have written proponent testimony from Stephen Green II with Opportunity Solutions Project, and from Elizabeth Patton, Americans for Prosperity. Do we have any proponent conferees in the committee meeting room or on WebEx? Seeing none, do we have any neutral neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none. We have opponent written testimony in your committee folder from Dennis Kreisel, Kansas Association of Local Health Departments, and Brandon Skidmore, Kansas Public Health Association. Do we have any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none. Committee, discussion on Senate Bill 304. It's essentially, as the reviser explained, removing the sunset provision in the Contact Tracing Privacy Act. It's set to expire May 1st, 2021, and so it's a small change that we are addressing while we are in session, and keeping, though, the privacy protections in place. I don't see any discussion then, so we will close the hearing on Senate Bill 304. And committee, if we could go ahead and turn to working Senate Bill 304 that we just heard. Do we have, I would entertain a motion. Senator Wilborn.
Thank you, Madam Chair. I would like to move Senate Bill 304 out of committee favorably.
Is there a second? Senator Bowers. Committee, discussion on the motion. Yes, Senator Thompson.
Just one quick question. So this permanently gets rid of that sunset. There's no view of the contact tracing. I guess we could at some point.
That, Mr. Reviser, Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. If I heard correctly, the question was if this permanently removes the sunset, and the answer is yes, it removes that provision. So the statute would remain on the books, but as I also noted, the definitions section makes it applicable only to COVID-19 at this time. So if the legislature were to go in and amend the statute to make it broader, it could, be handled that way, but the section itself would not expire as it's scheduled to now.
Thank you, Madam Chair.
Thank you, Mr. Thompson. Committee, further discussion on the motion. Yes, Senator Haley.
I'm going to stand in opposition to passing the bill. I didn't get a chance to hear the proponent testimony. I apologize for that. But in reading very rapidly the opposition, it seems very well reasoned that we are we should probably leave everything in place as it stands. We're going to get through this, Madam Chair. It won't be long now. We should just be a little more patient and let healthcare professionals have all the tools in the chest they need. So I stand in opposition to the motion to pass the bill favorably.
Committee, further discussion on the motion? Seeing then none. Committee, you have heard the motion. All those in favor, aye. All those opposed, no. The motion carries. And Senator Haley would like his no vote recorded. Thank you, committee. We will now turn to opening the hearing on Senate Bill 286. And before we open the hearing on it, we have 6 conferees. Actually, we're going to have, let me backtrack a minute. We're going to have discussion on Senate Bill 286. We have 6 conferees who are signed up to provide oral testimony, so we want to make sure everyone has time. We also want to leave some time to possibly address the contents of Senate Bill 286 today and some final action on some other bills that are in committee. So with that, we will need to conclude our discussion on Senate Bill 286 by 11:30. And committee, just so you know, Senate Bill 286 was heard in Taxation and Assessment Committee in the Senate. They had a lot of testimony provided in that committee, I think over an hour of testimony. So it's not a completely new concept that's being discussed today. It's a little bit different than what was discussed in tax, but let's get right to it. And for our 6 conferees, we will provide about 3 minutes each, and then we'll open it up for discussion, further discussion. Mr. Reviser, Mr. Thompson, could we have the bill brief on Senate Bill 286?
Thank you, Madam Chair. Jason Thompson with the Reviser. And just procedurally, I wanted to clarify the thing you said about discussion on this bill. The lack of referral from tax to judiciary means that this isn't a formal hearing on SB 286, but it is an informational hearing and a discussion on the contents of SB 286. And the bill brief I provided to the committee is the same bill brief that was presented to the tax committee, prepared by our tax revisers, just with the top part changed for your committee. And I won't spend very much time going into the details on this because my understanding from the conferees and the chair is that this concept is not necessarily the final product you're seeking. So I don't want to waste the committee's time talking about details of something that may not be really under consideration. But I will give you the broad highlight here. The Senate Bill 286 would establish the COVID-19 Governmental Use of Business Compensation Act. It would create a COVID-19 Governmental Use Claims Fund at the state level to provide funds for impacted businesses. It would offer income tax credits for impacted businesses. It would offer reimbursement to certain property owners of property taxes resulting from a forced shutdown or capacity limitation. And it would create a business loan forgiveness program. And just in broad terms, if you're looking for any of those particular provisions, Section 1 names the act as I just described it, gives the definitions of what a restriction is under the act, what an order is under the act that would entitle you to seek compensation. Section 2 establishes that fund in the state treasury that I referenced. And then Section 3 creates administration of the act by the Attorney General. Applications for reimbursement would go through the Attorney General's office. And once a determination was made that a claimant was entitled to compensation, they would issue a certificate, I believe is the term in the bill, that would entitle the claimant to then go seek either a tax credit or a tax abatement or both as their remedy under this act. And that remedy would be exclusive. They would no longer be able to go seek other remedies for the same damages. This would be their one bite at the apple, so to speak. And then sections 4 through 6 would govern the refundable income tax credits that I referenced. And finally, section 7, section 8 deals with the business loan forgiveness program that the Secretary of Commerce would create under that act as proposed. And with that, I'll stop and stand for any questions.
Mr. Thompson, would it be appropriate, I believe there is a balloon amendment that's being drafted or worked on. Would it be appropriate to distribute the balloon amendment at this time, or would that be out of order at this time?
Madam Chair, Jason Thompson again. Since you've now disclosed the amendment, I was working on an amendment at your direction, and it's entirely in your discretion as to when we hand that out. I could have copies made and sent up. I can, or we can wait. It's totally up to you.
Thank you. My understanding is that discussion in the informational hearing is on aspects of 286 that are similar but quite different from what is going to ultimately be proposed by the proponent. So let's go ahead and get those copies prepared to be distributed, and while we wait for that to happen, we will invite our first proponent conferee, Ryan Kriegshauser of Kriegshauser Nay Law Group, and we'll have 3 minutes. If several conferees want to yield their time to another, that's fine too. Just let me know. Welcome back to committee, Mr. Kriegshauser. Please introduce yourself.
Thank you, Madam Chair. Ryan Kriegshauser with the Kriegshauser Nye Law Group. And it's good to see you all again. I came and testified on the KEMA bill, and I just wanted to inform the committee that Eric Stafford with the Kansas Chamber has decided to yield his time to me. I just want to provide context. I've submitted written testimony that is somewhat lengthy, and so I think the context of this bill is the most important. This bill is brought to settle litigation. So right now, and I mentioned this during our KEMA hearings, I represent a gym that sued the state for compensation for government use of their property during the shutdown period with COVID-19 to cope with COVID-19. And that was brought under a current law. So KSA 48933 is a compensation provision that exists in KEMA currently. It's ambiguous, it hasn't been widely used, but the law tells us if your government property is used to cope with a disaster that's declared, this is the process to do that. And we took it to the court, we filed a lawsuit, and the Attorney General asked us if we would stay the lawsuit. We agreed to bring it to policymakers because obviously this is a global situation. It's not just our gym, but we are actively involved in litigation, but there could be others who are interested in pursuing the same litigation. And so the Attorney General thought, and we agreed, that the public policymakers of the state should handle this situation. So 286 was written prior to knowing exactly what federal relief was coming. It was written in January, February timeframe with a number of parties. So the assumption under SB 286 is that the state is in a certain fiscal position, counties and cities are in a certain fiscal position. So we looked at tax credits and property abatements over time to limit the fiscal impact, as well as assuming some federal funding would come in, that $100 million fund could be used as well. What we have found with ARPA, the American Rescue Plan Act, is that the state is slated to receive $1.6 billion. Counties are slated to receive $565 million. And so there is an influx of federal funds. And so what we're proposing, and what the balloon amendment essentially that the chair referenced, in talking to, or hearing from the opponents, talking to some of them, talking to members of the Assessment and Taxation Committee, the view on it is that we should take the tax pieces out. The counties did not like the property tax abatement. They were afraid that it was getting to funds that had already been spent. And so, acknowledging that this federal money was coming in, we discussed with the Assessment and Taxation Committee how to address this going forward. And if we take the tax pieces out, obviously, this is not a tax bill anymore. It's a bill to settle litigation. Thus, leadership decided Judiciary needed to listen to it and ask questions. So that's why we're here. And so the balloon that we would propose is to have the state, counties and cities segregate 25% of available federal dollars that haven't been encumbered, haven't been directed, to set aside, and then allow the Attorney General to come up basically with a class action settlement. The bill has some factors that the Attorney General's supposed to consider. It has rule and reg authority, so basically the Attorney General is going to negotiate on behalf of a state class action settlements, and depending on what order is in place for the claimant, that fund will be tapped. So if a claimant is complaining about restrictions on a county order, then the Attorney General will determine, based on the class action type settlement, how much that claimant is owed, and then the county will use its segregated fund to pay those claims. And so all of this is designed that claims must be in by a certain time, and after that time, all liability under KSA 48933 is dissipated. So basically, you have a choice. Do you want to file a KEMA claim under 48933, or do you want to use this kind of settlement process using federal funds to absolve the state of any potential liability, thus managing the litigation risk and hopefully get some of that federal money to businesses that desperately need it. And let's be honest, these businesses are the ones who were burdened the most for the general good. The general public relied on these businesses to shut down at a specific impact to them at their expense, and so the general public should compensate them for it, and in fact, that's current law. So KSA 48933 exists now, and this would help absolve the liability for that. I want to answer your question, so I will stop there and turn it over to the other proponents to be sensitive of time. But thank you. I'll stand for questions.
Thank you. And that was only about 4.5 minutes. So good job, sir. Thank you. Next, we have, and we'll have questions at the end after we've heard from all our proponent conferees. We'll invite then Mr. Andrew Weens from the Wichita Regional Chamber of Commerce. It appears he's on WebEx, so please introduce yourself and welcome to committee.
Yeah, thanks, Madam Chair. Can you hear me?
Yes, we can. Go ahead.
Great. Andrew Weens, Vice President of Government Relations with the Wichita Chamber. We stand in support of Senate Bill 286. I think Ryan did a pretty good job explaining it. Obviously, there's a few other factors at play now with some balloon amendments on the table. I will say that our support stems from several places. I think one is just the hope that this bill can help resolve some of the existing legal liability, which is under KEMA. And, I think attorneys, lawyers will argue about, there will certainly be legal disputes about individual cases and, the applicability of KEMA to the situation we find ourselves in. But we hope that this bill can help resolve some of the legal liability that currently hangs over various units of government. And then I think from a higher level perspective, we certainly want to represent our members that were harmed by restrictions during COVID, and hope that, some kind of COVID reimbursement can pass to help those folks out. I will just mention one thing in particular. I know there are certain amendments that you all will probably be looking at, but we did want to let the committee know that we would support some sort of amendment to remove the property tax portion of Senate Bill 286 as it's currently written. We've had some good conversations with Sedgwick County and some of our local units of government, and believe that taking out that property tax portion will resolve some of the potential budget ramifications for those units of government. So I did want to make sure to say that for the record. And as Ryan mentioned, the American Rescue Plan stimulus, federal stimulus has passed since this bill was written. So, we know a little bit more than we did before about how much money is coming into the state and various units of government and industries and education and childcare, et cetera. So I think that's helpful for you as a committee to consider. And I think just broadly, again, to restate, I think some of these shutdowns really devastated certain businesses, particularly small businesses and even whole industries, thinking about restaurants and bars and hospitality, but others as well. And so some of the restrictions that were put in place, without much data, because frankly, we didn't know a whole lot about COVID, particularly closer to the beginning, but there was just not a lot of data that anyone had to be able to justify some of these shutdowns. They really did have an impact and effectively prevented a slew of businesses from fully participating in Kansas commerce. So we hope that Senate Bill 286, as amended, if you'll consider our amendment and some of the other amendments that are being proposed, but certainly, again, want to make sure that we state our support for pulling out that property tax piece. But hopefully a COVID reimbursement bill can pass so that we can even the playing field for those who lost as a result of COVID. And so with that in mind, we support the bill with the ask for consideration of that aforementioned amendment. So appreciate the time, and I'm happy to stand for questions whenever it's helpful.
Sure. Thank you. Appreciate that. Committee, I have a copy of the proposed amendment that you've been hearing about. I'm comfortable with distributing it if our proponent would be comfortable with that. And if it's in proper order, Mr. Thompson, for me to distribute it, I'll go ahead with that.
Thank you, Madam Chair. Jason Thompson with the revisor. Yes, I believe it's your amendment, and you're allowed to distribute it as you wish.
Okay, great. Then committee, we will distribute the amendment. It's a balloon amendment, and you'll see that it outlines and it actually details, because it's a written amendment, the process and the proposal that you heard from our first proponent conferee, Mr. Kriegshauser. I'll wait till that's distributed, and then we will have another proponent conferee provide testimony. Perhaps we should have Mr. Thompson explain the balloon amendments first. If you'll go ahead, Mr. Thompson.
Thank you, Madam Chair. I can do my best here. Let me see if I can share my screen as well. It's often helpful. All right, there we go. So you should have the large balloon amendment for SB 286. I'll just start. The simple change in the title is maybe an obvious direction we're headed here. Rather than income tax credits and the other items provided here, we'd be continuing to create the act and providing funds for businesses and still providing for administration by the Attorney General. But we're requiring certain counties to establish and administer a county COVID-19 governmental use claims fund, and certain cities to establish and administer a city COVID-19 governmental use claims fund. So this proposed amendment would have a state, county, and city fund that would be created using federal funds, and that is where the reimbursement would be drawn from. The changes down here on the bottom of page 1, you'll see that the definitions do not change in section 1, still the same kind of restrictions, the same kinds of orders that get you qualified for compensation. But in section 2, where the bill establishes this COVID-19 governmental use claims fund at the state treasury level, we also have some language that beginning on January 1 of 2024, the remaining funds in that state fund could be used in any manner consistent with state and federal law. And then on December 31st of 2024, that fund would cease to exist. And the reason for that is because the monies from the federal government that are going to be put in that fund have to be used by December 31 of 2024. So until a certain cutoff point of December 31st of 2023, they're only allowed to be used for certain purposes in this fund. And then beginning January 1 of 2024, they could be used for any purpose that's permitted by state or federal law in order to expend those before they have to be expended under the federal law. That's my very general understanding. I'm not an appropriations reviser, but that's what I gathered from the discussion that led to this balloon amendment. The very bottom of the page provides that, except as we just talked about, the monies that are in this particular fund will only be used for the purpose of paying compromises, settlements, and final judgments arising from claims against the state under KEMA, the eminent domain laws, or other claims related to compensation for takings. So they're only going to be used for this particular purpose. And then subsection C on page 2 here is the key sort of provision. The director of the budget has to identify monies from the federal government for coronavirus relief aid to the state of Kansas that may be expended at the discretion of the state and are unencumbered. So they identify that pot of money, federal money, and of those identified monies, they determine 25% of that money available in special revenue funds, certify that amount, and transfer it to this fund. So the pot of money from the federal government, 25% of the unencumbered amount is transferred into this state fund and is available for claims made under this act. Hope that makes sense. The Attorney General then is in charge of the act, as I mentioned. That is what happens here on page 3. I'm sorry, I should note on page 3, all claims brought under this act must be filed with the Attorney General on or before December 31st of 2022. So there is a limitation. You have to file your claim before the end of 2022. But then obviously claims could be considered a little bit after that, but it has to be filed by that point. Then Section 3 provides all the procedures for the Attorney General to administer this act. Basically, a person who wants to make a claim has to submit an affidavit, some tax documents, identify the order that caused the harm that they're claiming, identify the amount of harm that they are claiming, and then the Attorney General has a process to determine whether that claim is valid or not. All their information is confidential. That's what the provisions down here at the bottom are talking about. It's confidential. It's not open records, and that expires unless renewed by the legislature within 5 years, the typical provision. Then on page 4, gives the Attorney General all the factors they're supposed to look at. There are 6 of them listed there in the balloon amendment and in the bill. And then once the Attorney General approves a claim for settlement or approves a claim for compensation, they issue a certificate. Sorry, I'm looking for the proper term. A certificate of government use. That's the term that's used. And that certificate of government use allows the claimant to go either to the state, the county, or the city that issued the order that aggrieved them to then seek compensation from the appropriate fund and the pool of federal money that's been set aside for this purpose. So that's what all of the changes to get to that point are dealing with. And you'll notice in Section 4, all the references to tax credits are changed to compensation that's approved or calculated by the Attorney General. So everything is compensation, not tax credits. That continues on to page 5, and then you'll see beginning on page 5 in line 10, the tax credit provisions in section 5, 6, 7, and 8 are all struck. So those would no longer be in the balloon or in the bill as proposed to be amended. So all the tax credit pieces are gone, and in their place, we insert page 7 of the balloon, which are 2 new sections drafted by our appropriations and local government revisers that require a board of county commissioners of a county that issues or has previously issued an order making a restriction as defined in this act. They have to adopt a resolution creating a county COVID-19 governmental use claims fund. And just like with the state fund, their administrator is required to identify monies from the federal government for coronavirus relief aid that are unencumbered and transfer 25% of those monies into this special fund that will only be used for compensation under this act until January 1 of 2024, when it can be used for any purpose allowed by state or federal law. Again, because on December 31st, those funds have to be used or lost, is my understanding. So that's what Section 5 does. Section 6 provides the same for cities. So if you're a city that's issued an order making restriction under this act, and there may be claims against you, you're required to create a city COVID-19 governmental use claims fund, put 25% of the unencumbered federal funds that you have into that fund, and then pay out claims through January 1 of 2024, again, as stated for the counties. That's a high-level overview. There's a lot more detail to it, but hopefully that gives you an idea of what's in here.
Thank you, Mr. Reviser. Questions for the reviser? Yes, Senator Pyle.
Thank you, Madam Chair.
Make sure you speak into the microphone so all can hear you.
I'm curious about the 25%, why that number was chosen and why not a higher number. I hope we can hear from the sponsor of the amendment as to why 25% was chosen.
Sure, yeah, and the amendment comes to us from the proponents of the bill. So let's finish with the proponent conferees, and then we'll open it up for questions for any of them.
All right, thank you.
Other questions for the reviser? Senator Gossage.
Yes, this is just a technical thing. It looks to me like that we would be duplicating the words providing for in the title.
It looks grammatically that you're correct, so we would need to
Thank you.
change that. I think the reviser would entertain that. Other questions? Yes, Senator Thompson.
Yeah, thank you, Madam Chair. Real quick question. So is the December 31st, 2024 date the point at which claims on this ends, and then any further claims will then go to 48,933, the KEMA? And is there a statute of limitation on claims for businesses? This could take some time to work through, and I'm just curious about those two things.
Mr. Reviser, if that's a question for you or if it's a policy question for the conferees, let us know.
Madam Chair, Jason Thompson with the reviser. It's a bit of both, and I'll give you the sort of legal answer. The statute of limitations for 48,933 claims is probably the general civil statute of limitations, and hopefully Mr. Kriegshauser can speak to that since he is an attorney working one of those cases. I'm pretty sure he would know the answer to that. So I'll defer. I suspect it's 2 years, but I'll defer on that just in case I'm not correct. But the statute of limitations under this act for claims made to the Attorney General for these funds is that provision I mentioned on page 3 in line 12, December 31 of 2022. So that's the time you have to file your claim under this act. That's the hard cutoff. Once that's done, then you get into the funding issue, which references January 1 of 2024 or December 31 of 2024. And those dates are tied to the federal restrictions on those federal monies. Because they have to be spent by December 31 of 2024, the bill essentially sets aside this pot of money until January 1 of 2024, only for this purpose. And then after that date, for that final year where those funds have to be expended, they can be used for other lawful purposes under the federal and state restrictions, but they're not restricted to just compensation as they are until January 1. So it's a little complicated, and I hope that gets at the question.
Thank you, Mr. Thompson. Senator, does that?
Yeah, that answers my question, I think. I'll like to hear from...
We'll hear from the conferees, and absolutely. Yes, Senator Gossage.
Thank you, Madam Chair. One more question, Mr. Thompson. In the title, it states certain cities. Have we clarified within this piece of legislation what are the certain cities and what determines a certain city?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again with the reviser. And yes, that's one of our favorite words that takes the place of many words sometimes. The certain counties and certain cities are described in section 5 and 6. Those are counties or cities that issue or previously issued an order making a restriction under this act. So if you have done that, you are required to make one of these funds. If, for example, your county or city did not issue any orders that issued a restriction under this act, say your county or your city did not do any action related to COVID-19, no businesses were ever closed, no mask mandates were ever issued, arguably, you do not have to make one of these funds. So I didn't want to say all cities. It's only certain cities that meet the definition of section 5 and section 6. Or counties and cities, I'm sorry, that meet 5 or 6.
Thank you. Other questions for the reviser? Seeing none, then we will have our next proponent conferee, Mr. Scott Schneider with the Kansas Restaurant and Hospitality Association. Please introduce yourself and welcome back to committee.
Thank you, Chair, members of the committee. I'm Scott Schneider, here representing the Kansas Restaurant and Hospitality Association. I appreciate you having this hearing. It's been one long year, I can tell you that. We started exploring the cliffs that our statutes created last summer, the Joint Economic Recovery Committee and taxes were one of them, and thus the Senate Bill 149 is over in the Tax Committee. And then Ryan Kriegshauser came up and approached us about his lawsuit, and we said naturally it fits with our position, because what's happened is partly good. There's been a lot of support. I know that Wyandotte County, for example, has given grants in their previous CARES Act money, so we appreciate that. I know the Hire Fund gave out $5 million and forgave those loans to a few hundred restaurants. The problem is there's 5,000 licensees in the state of Kansas. So this bill would serve to fill the gap that was created in some of these other programs that just weren't large enough to help everybody who may have been impacted. For example, last March and April, we laid off in the industry 64,000 employees. So we had a conversation with Sedgwick County. We understand that they didn't like the property tax idea because they may have to lay somebody off. Well, 64,000 in the industry was quite a hit for us also. In that first month, we also lost $325 million of revenue. And that continued until people kind of retooled their businesses. Not all businesses, restaurant businesses, lost money. The fast foods and the people with the drive-through and delivery programs, some of them did really well because they were able to reduce their costs so much. So as we think about what the cost is, there is significant exposure out there, I think, in the state, and this idea of tying it up into a class action settlement, our industry would support, because we think a lot was asked of the restaurant industry to get through this. A lot of shutdowns happened. You have my testimony. I'll stop there to allow you guys to ask questions if you have them. Thank you.
Thank you. Do we have other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then, committee, we will open it up for questions for our proponent conferees. Senator Pyle.
Madam Chair, if we're going to question proponents, are we going to be talking about the amendment or the bill?
Thank you, Senator. I was thinking to clear that up myself. My understanding is that the proponents want to address the amendment, so I would suggest addressing questions to the amendment.
Well, with that, Madam Chair, I'll move the amendment so that we can adopt the amendment, and then we can work from that.
Okay, then do we have a second for the motion? If that's in order, Mr. Reviser, Mr. Thompson, would that be in order at this moment?
Madam Chair, Jason Thompson with the Reviser. As far as working SB 286 itself, that bill has not been referred to your committee. So I would caution that you probably cannot call that up for action and issue a committee report on it. You can still consider the amendment without it actually being offered. So you could skip that step for now until you're ready to work the bill at some future time.
I think what we would propose to do is, after we have the hearing and when we have the discussional informational hearing, then we can move the contents of the amendment in front of us into a House bill, a shell, if you will. Is that correct, Mr. Reviser? And work it that way. Is that Senator Pyle? But is that correct, Mr. Reviser? How would we be able to work the contents of the balloon amendment of Senate Bill 286?
Thank you, Madam Chair. Jason Thompson again. Much like any other bill that is not actually referred to your committee or that has been heard by your committee, has been sent out, or something like that, you can call up a House bill, any House bill that you choose, and the first motion potentially would be to amend that bill by removing the contents and inserting the contents of some other balloon, some other bill, etc. So that would be the typical procedure, and then you would be working that House bill that you have in your committee. You would not be working the Senate bill number, but you would be working the Senate bill content at that point.
Understood. Thank you. Are we ready for that kind of motion, or is it more in order to continue the informational hearing first?
Madam Chair, Jason Thompson again. Technically speaking, you've opened this informational hearing and discussion, so it would probably be best to finish that before moving to working and calling up a House bill for final action for that purpose. So procedurally, I think it would just be a little cleaner if you waited to take that procedural action.
Thank you, Mr. Reviser. Committee, we can discuss the contents of the balloon amendment, Senate Bill 286, that is in front of you. Discuss that with the conferees who have been providing information for our informational hearing, or excuse me, our informational discussional hearing. And when we are concluded with that, then we can conclude the informational hearing. We can open up working a House bill and entertain a motion to put the contents of the balloon amendment into the House bill. So let's continue with our informational hearing with, I would suggest, directing questions, since the Senate Bill 286 isn't referred to our committee either. We are then having an informational hearing regarding Senate Bill 286, including information on the proposed amendment to Senate Bill 286, which is in front of you. And with that, then we will open it up for further questions. We don't have a second for the motion because the motion is not in order at this time.
I'll withdraw the motion, but it's kind of interesting. I come to committee and we've got it on the calendar that we're having a hearing. Where is Senate Bill 286?
Mr. Reviser, if you could confirm, I believe Senate Bill 286 is currently in Taxation and Assessment Committee in the Senate.
Okay. Well, I just think it's kind of interesting that we're having hearings on a bill that we don't have in this committee. I understand that we could have informational hearings on the contents of that, but I think that should have been laid out clearly, plainly for us as we came. And now we have an amendment to a bill that is not in our committee. So I understand what you're doing. It would have been nice if we'd have just started off with a House shell, put all this contents in it, and then had a hearing on it, and backed up, because now we put into question and into play the questions surrounding this issue on this bill going forward. But I do have a question for Ryan Kriegshauser on the amendment, Madam Chair.
Let's hold that question for just a moment. And Mr. Reviser, then, would it be in order to close the informational hearing, open up working a House bill, and as Senator Pyle suggested, then amend the House bill and reopen the informational? Then we could actually have be working that House bill.
Thank you, Madam Chair. Jason Thompson again. Generally speaking, when you're working a bill, you're not taking testimony and discussion from anyone outside the committee, with rare exceptions, as you have allowed here and there. So I would say what you're doing now is more the typical procedure, where you're having an informational discussion, planning to work this content in some way. And yes, it's unusual because of the way the hearing was noticed up. I believe you intended to have the bill referred, and it just did not get referred through no one's fault particularly. So in my very general opinion, you're following the normal procedure that you would follow. And if you were to do the other procedure, you could, but then you'd be working a bill and taking discussion from non-committee members, which is unusual in my experience.
Thank you, Mr. Reviser. So we will go ahead then and continue with the informational discussion on the contents of Senate Bill 286, which include a proposed amendment to Senate Bill 286, which committee has in front of them. And then we will open it up for questions for our proponent conferees, with the thought in mind that we will later work a House bill and put the contents of Senate Bill 286 amendment into that House bill to later work it. With that then, committee, do we have questions for our proponent conferees? Senator Gossage.
Thank you, Madam Chair. My question is for Mr. Kriegshauser. Thank you for being here. If it explains in the bill that if there are additional funds left over, what's to be done with those funds. What it doesn't explain is, what if these funds are not enough? So is it first come, first serve?
Thank you, Ryan Krigshauser, Krigshauser Nye Law Group. No, that's an excellent question. And so one of the factors that the Attorney General is to consider is the amount of funds available for distribution. And so the counties and cities have to certify the amount of funds available to them, and then the Attorney General will work with a global picture of the number of funds available to settle these claims in a class action type settlement. So the Attorney General's office will have a clear picture of the global amount available. And to your question about whether or not it's enough, I don't know, given the compensation and liability that I don't know what the damage is. And I think that's one of the things that came up in the Taxation and Assessment Committee is, I mean, the damage is immense, and whether or not we have enough federal funding and whether or not 25% of it is enough to cover that. This is a settlement, and I think we get the best we can get in that situation, but it's possible that the state could be liable for more under KEMA claims.
Yes, go ahead, Senator Gossage.
Thank you. Mr. Kriegshauser, can you explain, I'm a non-attorney, and I'm sure there are non-attorneys that are listening. Can you explain the difference between a class action suit through the Attorney General's office and, say, a private attorney on behalf of a business bringing that and creating suit to the state?
Correct. And I wouldn't say this is a class action. It's a class action because generally class actions are in courts and a judge would supervise the settlement of it. And this uses more the Attorney General in that role. The difference between our case, so the GEM that's sued the state under KSA 48933, the process that KEMA contemplates is that a court will appoint a board of appraisers to look at that individual business and determine the amount of damage given the government use, and then file a report with the court, and then either side, the state or the county, whoever the defendant is, in our case it's the state, or the claimant can challenge that and seek a jury trial. Obviously, attorneys will be very involved in that process, and it is expensive for the litigants, it's expensive for the state. But it's possible that the result could be more equitable because it's looking at that individual business. And so the amount could be more than they could get in a class action type settlement, which probably would be pennies on the dollar compared to what they could get if they go through the litigatory process. But there are a lot of mines, there are a lot of defenses that the state would assert, and again, attorneys will be involved and it will be expensive. And so this is kind of a give and take. People could be willing to take less money through an expedited process using these federal funds.
Thank you.
Thank you. Yes, Senator Thompson.
Thank you. And I think that the revisor sort of deferred to you on the statute of limitations question. I mean, say somebody doesn't want to engage in this, but later on down the line wants to sue under 48933, do they have time, or does their time run out?
I think the revisor's office is correct in the general statute of limitations probably applying, which is 2 years. And so the question is, you have a running 2-year window, though, depending on the restriction you're complaining of. So if it's a complete shutdown, that would have been March, April of last year. And so you would still have till March, April of next year if that statute of limitations apply. But counties have been issuing restrictions for a long period of time. And so that statute of limitations could be continuing even now, depending on the types of restrictions that are out there. And so 2 years from today, if there was a restriction that was actionable in place currently, then 2 years from now, that restriction could be sought under KSA 48933. And so that's why there's a cutoff in the bill saying you have to have your claims in by this date, and after that, the state is absolved. And if the statute is run, you're out of luck, but most likely there will be some statute left even at that point. Just it's very complicated depending on the restrictions that are at issue.
If I may, a quick follow. So, and to follow up on Senator Gossage's point about the costs, we've got a huge windfall of money coming from the federal government that I'm sure that cities and counties and even the state are looking at glowingly. who determines then, is it the federal government that determines how the funds are encumbered, or do the individual entities, the state, the city, and counties? And could they, in fact, say, we've got plans for all this money coming on down, and your pot is shrinking? Would it be better to set a minimum amount to say these cities cannot, the 25% threshold, for example? You know, these businesses, and I would like to know how many businesses are impacted by this, and then do the math and say, you know, are these guys going to get $100 for being shut down for a year? Do you see where I'm going with that?
Yeah, I think that's a good question. The problem is this federal money has been coming in, and I think it's very difficult to get granularity on where it has been going, much less the money that is yet to come. And so Treasury hasn't even issued full guidance on how ARPA is to be spent, but we do know it's for recovery. We know the intent of the federal government and to allow units of government to have more discretion than under the CARES Act. So it's conceivable, and that's why the language is worded the way it is, for the director to go and gather these monies, because honestly, I don't know that someone has done that currently. And so they would have to go out and see what encumbrances are out there, what plans are for these federal funds, and then what is still left over, 25% of that would be applied to this. And so I think that's the difficulty, is it's a moving target.
I think that answers my question. It's vague, but it's unfortunately. Yeah. Thank you, Mr. Kriegshauer.
Thank you. And with that, we're going to, because we're running short on time, we will ask our proponent conferee. We're going to have the neutral conferee provide some testimony, and if we need to open up the informational discussion to all the conferees for questions at the end, we can do that, but let's see, perhaps the other conferees will answer some of the questions. So with that, we will invite Trey Cocking of the League of Kansas Municipalities. Please introduce yourself. You've got 3 minutes, and welcome to committee.
Thank you, Madam Committee Chair. I appreciate you having us here today to talk about this issue. I think
go ahead and introduce yourself.
Sorry. Trey Cocking, Deputy Director, League of Kansas Municipalities. I think the balloon makes this bill better, but I don't think we're there yet. Number one, this bill presumes that your 2019 profits would be your 2020 profits without shutdowns. And I think that is very flawed thinking. On my testimony, I've included all sales through Affinity Card Solutions from Iowa and South Dakota, 2 states that did not have shutdowns, and from Kansas. The Kansas shutdowns were less. Our drop in consumer spending in Kansas was less than Iowa and South Dakota. So I think when we're looking at the solution, we have to have proximity. We have to have that the shutdown actually did cause the damage. I think sometimes it probably did. But I think to authorize this to everybody, even if they were not, if it was the consumer not feeling safe, if they stayed at home, or, you know, nothing moved. People were scared to death last March and April. If you go back in time, regardless of whether or not there was a shutdown order, people weren't going out. People weren't going to bars. People weren't going to restaurants. And it wasn't because of the government shutdown order. It was people were scared for their lives. And I think that's something this bill needs to complement is maybe we do want a grant fund that has nothing to do with damages to help these businesses out. That's an entirely different conversation than saying your 2020 sales were not your 2019 sales. That is directly due to government action when it was not directly due to government action. So I think that's something we need to look carefully at. And the other thing I really want to point out is I've been through this with our cities. I am not aware of any city that had a restriction in place other than a face mask ordinance. That is the only thing we've seen. And to be very truthful, most businesses will tell us that they felt better once the face mask ordinances were in place, and that they had a tick up in business once face mask ordinances were in place because people felt safe and they were going out in those cases. So we would ask for a further amendment to make it clear, and I've talked to the proponents about this, that after May 1 with the face mask ordinance, we want it really clear, and the proponents are okay with this, that you're only liable if you require the business to enforce that face mask ordinance. So if it's just on the consumer, it's not a restriction. However, if you're telling the business to you need to have a security person out front to enforce it, then that probably is a restriction, which costs money at that point. So we would ask for that change, and that language is in my testimony, Madam Chair. And I'll stand for any questions.
Thank you. Do we have any other neutral conferees in the committee meeting room or on WebEx? Seeing then none, any questions from the committee for Mr. Cocking? Yes, Senator Gossage.
Thank you, Madam Chair. So you said you just had the mask mandate, but I know many cities also had the social distancing, which caused restaurants and other.
Those were all county orders. We are unaware of any city orders that had that requirement.
Thank you.
And I sent it out on our listserv yesterday asking for it, and I have not. No city. We had heard Manhattan, but that was a Riley County order. So everything really looks to be at the county level versus city level, which is what it should, because that's where the health board lies.
Senator Thompson.
Yeah, the population of South Dakota, for example, is only 884,000. That's a little bit more than Johnson County. So I would imagine when you show the graph percentage of consumer spending, I would suggest that there's a large difference in they're very rural up there, and Johnson County is very urban, so the consumer spending might be quite different. So I'm just wondering, that comparison, is that relevant?
And that's why I added Iowa, which I think Iowa is very on point. Iowa is going to be very similar to Kansas, and our spending was higher than in Iowa.
Okay. Thank you, Madam Chair.
Committee, further questions for the neutral conferee? Senator Pyle.
Thank you, Madam Chair. Trey, so if a city puts on a mask mandate, but the businesses aren't required to enforce it, but the city is enforcing it, is that not going to be a restriction to that business?
How are we causing business harm with the mask ordinance?
I will use my area, for instance. I know that businesses were harmed because the city still has a mask mandate on, and there are still people that will not shop in that community. They drive to Sabetha, you know my area, they drive to Falls City, or they'll take off and go to they go where they can shop without a mask mandate.
And there's the same people who won't go shopping if there's not a mask. I mean, Marysville, Missouri saw a intake in sales once they put the mask ordinance, because there's people who do not feel safe. So yes, you get half the people who say, I'm scared for my life, I'm not going to go shopping. Other people, how dare you take away my freedom?
Right.
You know, I think if you can show that math, I think we are willing to look at it. But just saying simply you had it, I'm damaged. Let's see your math.
I'm just saying that a mask mandate does cause restrictions. It causes restrictions economically in certain areas, and there are businesses that are going to be impacted whether or not they're enforcing the mask mandate or not. So you understand that.
And I will say we had very much the other conversation that we were told sales went up once mask mandates were put in place in other places.
And I can see how maybe that would happen, but I could also see the reverse of that too.
Yeah.
Yes, Senator Wilborn.
Thank you, Madam Chair. Very briefly, maybe I missed it. What was the proponent's response to your amendment? And maybe you addressed that.
They are okay with it. It's in bold in my testimony.
Thank you.
Senator Thompson.
Is the duty to prove that you've been harmed by the mask mandate upon I guess it would be upon the claimant, correct?
And correct, and honestly, with this language that's in here, it's going to be after May 1. So, I mean, I really think we are heading towards repeal on most of these mask mandates. I would really ask for May 31st, because I think we're done by May 31st with vaccinations and everything working. I mean, I look at the numbers every day, and we plateaued, but I think by the end of May, we will be out of this.
Just a very quick follow-up, if I may. We're in an urban area, and we've got a business that serves and caters to rural people. And the owner of that business has told me specifically his business is down significantly because these folks come in and they see there's a mask mandate and they don't want to put up with it. They're coming from outside of the city this is a Western wear business, and they're being harmed significantly. So how do you measure, when you say, well, it's, the city, there's no impact. Now, how can they possibly collect on that and prove that? It's a sentiment of a consumer. It's going to be, the threshold for them to prove that damage is going to be awfully high. And I'm just worried that there are businesses that are being negatively impacted that won't get compensation because the threshold of proof is so high.
I think all we're asking for is some language that shows that it's, I'm trying to think how this works. Yes, I don't think you can easily prove it. Now, obviously, if you were to make the other claim, you would have to prove it in front of a jury. The option under law now, the option under the Fourth Amendment. I think we just want a recognition that the government order is not 100% of why your sales were off from 2019 to 2020. There are other factors.
I think the government order was probably a very, very significant portion of it.
I will tell you, my wife has ate out once in the last year, and it's not because of a government order. She just hasn't felt safe eating out. And she did the research, and she thinks that's where most people are getting COVID, is from eating out. And she hasn't ate out. Now, I've ate out more than that, and that's caused some tension in our household. But, people do what they do.
Thank you, Madam Chair. Thank you.
Committee, other questions for the conferee? Seeing none, then we will ask our opponent, conferee Pete Meinsner, with the Sedgwick County Commissioner. Actually, he is a Sedgwick County Commissioner. I apologize. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I'm Pete Meinsner. I'm currently the chairman of the Sedgwick County Commission, and thank you for delaying this a few more minutes into your hearing. Senator Kelly, or Senator Warren, I'm sorry. I'm not sure we've met, but we start out as an opponent on my testimony, but based on the balloon amendments as we were paying attention to it, it really addresses the only thing that we were going to request, which would have been the as you know, the negative impact of property tax refunding, and we have written testimony in there what could have possibly happened on future tax increases or cutting of services, police or fire and jail, things like that. So you've really, I compliment that you have you and the committee have come up with this amendment. And is 25% the right number? I don't know. That's to be determined. Johnson County and Sedgwick County were the only two that have experience besides the Spark Committee on distribution of CARES money. So in the past, we distributed 99 million. I think Johnson did about 110 million. So we are very familiar with the federal laws and guidelines that's been referenced before. So assuming that this thing will work within the federal, the American Rescue Plan Act, if it's going to have guidelines, and hopefully if their intent is to get the funds into the communities, that's what we did, everything we could to get the CARES Act back into the communities of Sedgwick County. And we would be full force in whatever we can to support that. So I guess instead of an opponent, we're at least neutral, and I don't have my fellow commissioners here to take a formal vote, but the way it's written, you've addressed our concern with this amendment, and we would probably even be supportive and a proponent if need be. So respectful of your time, I'll stand for questions, but I want to thank you for allowing me to say a few words. And again, Senator Warren, I can't say enough about the work you did to come up with this balloon amendment. Thank you.
Thank you, Mr. Meitzner, but I can't take credit for the balloon amendment. It comes to us from the proponents, and we will be looking at that. So thank you.
Okay, well, my
Do we
thanks
have,
to Krackheiser, Mr. Krackheiser also for doing that, for being flexible. Thank you very much.
thank you for your testimony. Do we have any other opponent conferees in the committee meeting room or on WebEx? Seeing none, committee, you do have opponent.
Chairman Warren,
Excuse me. Yes.
I apologize. This is Jay Hall, Legislative Policy Director and General Counsel for the Kansas Association of Counties.
Okay, great. We had you down as written, but you're here, so go ahead, please.
I apologize. I got that in as quickly as possible last night, and I wasn't sure if that got in clearly for your committee assistant. I'll just touch on a couple of things. As Commissioner Meitzner said, the amendment appears to probably move us from an opponent to probably neutral. I do want to touch on a couple of things that have been mentioned, though. And the first is with regard to the American Rescue Plan funds. We are still waiting on that Treasury guidance. And so while we're not opposed to setting aside those funds for recovery of different industries, we are waiting on what rules are going to govern that, so that we can commit to making sure that we get those funds in the hands of people in accordance with the federal guidance that comes out. Hopefully, that's supposed to come out within 60 days of the passage of the plan. So here in another 45 days or so, hopefully we will have that information in hand and be able to move forward with that information. As well, I wanted to also mention briefly that within the American Rescue Plan, aside from the money that's going to counties specifically, there's also a restaurant revitalization fund, and that's about $28.6 billion that's being distributed specifically to restaurants. And I have a handout that I can send to the committee assistant that can supplement some of my materials here. And so I do appreciate the amendment, and I think that moves us from opponents to neutral, but I did want to get that other information out there as well. And I'd be happy to answer any questions.
Thank you, Mr. Hall. I appreciate your testimony. So with that, committee, we will open it up first for questions for our opponent listed conferees who now have said they are the Sedgwick County Commissioner is a neutral / maybe a proponent, and the Kansas Association of Counties is now a neutral, if I have that right, Mr. Hall. Yes.
That's
okay.
correct.
Okay, great. So any questions for Mr. Meitzner or Mr. Hall? Yes, Senator Haley. Just to clarify that pending, they are neutral on the proposed amendment to Senate Bill 289. I'm sorry, 286, and not on the bill as it is originally written. So with that, committee, do we have questions for Mr. Meitzner or Mr. Hall? Seeing none, then we will open it back up for discussion with any of our conferees. Yes, Senator Gossage.
Thank you. I have another question for Mr. Kriegshauser. Thank you, Madam Chair. I noticed that there is no fiscal note with 286. My concern is that we have this huge undertaking in the Attorney General's office. I'm envisioning all these questions from businesses, reviewing applications, determining how many apps are eligible, dividing by that the number of funds, dispensing the funds. Are these to be paid out of that staffing up for all of this to be paid out of the 25%? Will that come out of the general fund?
Go ahead, identify yourself first, please.
Ryan Kriegshauser Nye Law Group. I think the fiscal note on SB 286, the Attorney General did submit that there were 3.5, expected to be 3.5 FTEs that would be used to administer that fund. I don't know if that increases given the more global situation that we have here with 25% at the state level and then local levels. But I'm trying to remember it. I don't think there's language directly in the bill saying that the Attorney General can use that fund to pay the staff, and I just don't know if ARPA would allow for that. And so we're still, again, waiting for guidance from Treasury, and so that's why we were hesitant to say you could use the fund to pay the expenses of administering it. But the language in the amendment basically says if the federal government allows it, then it can be used for, those settlement purposes. But I don't think that it expressly says that they can use the fund to pay staff.
Thank you. And my second question, very short, is you had mentioned earlier about the state using your property. Can you give us an example of what that means?
I can't, because the statute doesn't define it, and that's been one of the problems here. There's actually a House bill that's been submitted that would define what use is, and this came up during the KEMA discussion. I think in my testimony there is that the 48933 is incredibly vague. It talks about a taking, and then it talks about use. So use is something different than a taking, and I would say it's a lower standard. But what use is, I would argue, is an exertion of control, and that would be shutting a business down or restricting it. And so it seems very broad what use is, but the statute does not define it. So litigation will define it.
And so use is not, the use of property is not in your bill. That's in KEMA?
Yeah, that's in KSA 48933. I've submitted language, but it hasn't moved anywhere yet.
Thank you. Thank you, Madam Chair.
Thank you. Senator Corson.
Thank you, Madam Chair. I know this is all new and fast-moving for every state, but if you know, can you give us any sense of kind of how other states are approaching this or thinking about approaching it? Just kind of, I want a solution that works for Kansas, obviously, but I am curious of if other states have started down similar other tracks. And then I'm wondering what your thoughts would be. Do we need to put in here any sort of language about, if this passes, that it has to be consistent with the American Rescue Plan guidance or something like that, so we're not going down this path and then finding out later, oh, it turns out that we're not able to spend the funds in the way that we thought we would be able to? I'll just be curious of your thoughts on both of those.
Yeah, two excellent questions. And I might defer to the reviser because I did have some correspondence with him exactly on your second question, that we needed language in there to say if the feds say we can't do this, which I think would be a very bizarre situation, because that's the intent of ARPA, is to get it to businesses that were impacted by COVID. But there should be language in the balloon, and I actually haven't seen the very final version of it, but there should be language. So I defer to the reviser on that second point, but we should be good based on my correspondence with him last night. As to other states, I might defer to Mr. Snyder. I know that Michigan did set up a fund for businesses. I think it was $500 million, but I'd have to defer to him, and maybe Mr. Stafford might have some information about what other states are doing. But I do know that other states do have compensation provisions in their emergency management acts. And I've talked to lawyers in a number of other states that are very curious about what the legislature does and how our case proceeds. So,
Senator Pyle.
Thank you. The 25%. Now, these funds are going to come, and there's going to be restrictions on them, what they can be spent on. So let's just use for an example. And you're setting aside 25% to handle impact on business-related issues. I'm just questioning if that's high enough, because I will use, for instance, and you tell me if I'm wrong. So in this Capitol building, we have 4 new screen monitors in this room. We have an employee that is handling and directing traffic on the meeting, WebEx. Is that a legitimate expense that the money that comes from the feds will be able to cover?
As far as the 25% being the right percentage, that's for this body to decide. And the reason we put 25% in there is actually in deference to the counties. I think Sedgwick County said 25 million was their low point, their low mark for what the original SB 286 would cost, up to 25 to 50 million, I think is what they said. And so they would get, I think it's estimated to be $100 million. And so that's where the 25% figure comes from. But it is a public policy decision that is up to this body. I put 25% in there to be a starting point to get the discussion started, but.
Well, what I'm asking, I guess I'll rephrase it. So if you build into the budget, such as maybe a county put a health worker at the door to screen people as they're coming in, so that was a COVID expense, and they count that. But they're building that cost in, so it's in the budget. So at some point, the COVID money runs out. The taxpayers are left to fill that gap of that budget building. I mean, I don't see WebEx going away. I see it here as a continuation, even as a result of COVID, but it did come about because of COVID. So I guess my question is, the 25% policy, if we don't designate a bigger percentage of that to help the businesses, the restaurants, the entities that were actually impacted by this, those are the tax-paying entities that are going to be helping provide the funds to cover this ongoing expense. I'm just questioning if 25% is enough, because we don't know. So should we not require up front a larger percentage so that we make sure we have the money to cover the impact, rather than setting the lower bar and then the money is gone? And I'm just questioning it, Madam Chair. I wondered where the 25% came from, because to me it ought to be a lot higher until we know what the impact is and who's going to come forth and request help and aid.
Ryan Kriegshauser, I understand your question more, and I think that's one of the reasons why we felt like these ARPA funds should go to businesses instead of building government, because that increased government footprint, if you will have to be fed by tax dollars. So it makes sense to us that a good amount of that money should go to the businesses impacted, and I think that's what you're getting at.
Thank you. Committee, we have one last question, Senator Thompson, because we're running late.
Yeah, I appreciate it. Very, very quick. You're talking about 25% of the unencumbered funds, correct? Just to clarify. Did you consider all unencumbered funds? Because it would be a bigger, and I agree with Senator Pyle on this.
Ryan Kriegshauser. Again, I would defer to the committee. I'm not elected, and this is your public policy decision. And so we started with 25%, as I said, kind of referencing Sedgwick County, but it is a decision for this body to make what that percentage should be. So I defer to you.
Thank you. Thank you to the conferees who appeared in person and on WebEx. Committee, we are currently past our scheduled meeting time. We do have other bills to work. I'm concerned that committee members have other obligations after our scheduled time. We do have a committee meeting on Monday. We will be taking up the appointment of Rebecca Dickinson as a member of the Crime Victims Board of Compensation. We will also on Monday be working bills previously heard, which would include Senate Bill 301, House Bill 2082, and we'll see what else we have time for, because we do have to get through that confirmation hearing, and Senate Bill 301 is rather large and lengthy too. Do we have questions from senators? Senator Pyle.
Madam Chair, are you going to wait for 286 to be referred to this committee to do this, or do you want to, I mean, it wouldn't take long to put this in a House shell. I believe you have some House shells. We put the contents of the amendment and the language in it so that we would have something to work on Monday. I'm just asking.
Let's go ahead. Let me check what we have. If you'll hold on just a moment, Senator, and we'll stand at ease. appreciate the question. And we're going to go ahead and look at it again on Monday and see if it comes, things like that. So we can always put it in a House bill then as well, which won't take terribly long either. So appreciate the question. With that then, committee, please come prepared as you were today to work. I appreciate your work today, and we will have the confirmation hearing and be working other bills. Thank you very much. And with that, we will conclude the informational hearing on Senate Bill 286, and we are adjourned.